Are you looking to put your products in front of millions of customers? Then Walmart Marketplace is for you. With more than 120 million unique monthly visitors according to Comscore, Walmart Marketplace is one of the fastest growing e-commerce platforms. Join today and gain instant access to millions of customers from one of the world's largest retailers. Go to marketplace.walmart.com. That's marketplace.walmart.com. Welcome to Ecommerce Conversations, a weekly podcast from Practical E-commerce, hosted by entrepreneur Eric Bandholz.
What is going on, Internet? Eric Bandholz back again with another e-commerce conversations. Hope all is well on the other side of the internet. On the other side of the internet from me is Mark. Welcome, man.
Thanks for having me.
Oh, man, you got to bring the energy. You got some energy in there?
I'm going to muster it all up for you.
Okay, well, I got the energy because we finally... I hate using the term won because we didn't win. We didn't win, but our lawsuit is finally over, and it was dropped by the plaintiff. And Mark was the dude who helped me do that. So why don't you give our listeners a real quick rundown of who you are and what kind of work you do?
Sure. Hi, everybody. My name is Mark Berkowitz. I'm an attorney at Tarter, Krinsky, and Drogen in New York. My background is in intellectual property. I started out as an electrical engineer, became a patent attorney, patent litigator. From there, transitioned into doing a lot of trademark litigation, and then transitioned into doing a lot of e-commerce related work, representing lots of e-commerce sellers, Amazon sellers, and things like that, and all kinds of interesting litigation like this one.
Yeah, I mean, it seems like, from my perspective, what we went through is frustrating because it feels, frivolous, or it feels predatory in nature. It seems like there's a gray area in the law that predatory lawyers will be able to attack. But can you give like a real quick rundown of our case and kind of like what we saw? A lot of all this is public, right? Because they post the docket. So if you search the case, Beardbrand
Sure.
versus Ugly. Is that how you pronounce her name?
It's Nunez versus Beardbrand.
Okay,
Yeah.
Nunez versus Beardbrand. You'll be able to pull it up and kind of see what's going on.
Sure. Yeah. I mean, so you were the target of a very common website ADA case. You're one of 20,000 plus websites that have been hit with these cases over the years. There's 4,000 or 5,000 of these filed every year. The idea behind them is that there's a series of laws that were created to protect disabled individuals, people who are blind, people in wheelchairs, and things like that. And somewhere along the way, the certain courts and the Department of Justice decided to expand the definition of a public accommodation, things that needs to be encompassed in these laws, to include websites. And that led to these types of websites where you have basically plaintiffs' lawyers, selecting an individual to act as the representative of the class, and to say that your website does not provide sufficient accommodation to people who are blind. The gray area in this particular instance is significant because there's really no set laws. There's no clear answer as to what's required, right? You have a set of guidelines out there that the industry tries to follow. There's nothing saying for sure that you have to meet a certain level, that you have to be at a certain place. So it's really all gray area. So your particular case was brought in a New York State court. It's one of we really see all these cases in New York. Some are brought in the federal courts in New York. Some are brought in the state courts. And you were hit with one in the state courts. And how you handle them and the options you have varies depending on which court you're in.
Why is that? So from my understanding, like state court are penalties under $75K and federal court is over that, or?
No, it just depends on the particular statute that they want to sue under, right? It's not under the federal law, you're suing under it's Title III of the Americans with Disabilities Act. That statute doesn't provide for any monetary damages. what they're really holding against you is the cost of litigation, right? They're going to, their threat is that they're going to drag you through a long litigation. You're going to spend lots of money. So why not just settle with us? So that's sort of the federal, the law firms that are suing in federal court. That's their tactic. The law firms that are suing in state court, they're suing under New York State and New York City laws that do actually provide for monetary damages. Some of it can be significant. And you can attack them in different ways. And in the state court case, what you can do, or at least some of the cases there have allowed the defendants to do, is to say, look, as a practical matter, plaintiff, you never reached out to us. You brought this lawsuit. You claim to have tried to use the website and not been able to place an order, but what did you do from there before you just filed a lawsuit? And that seems like a very common sense approach to it, right? Because if this plaintiff here had reached out to you, right, had said, I'm having trouble with your website, what would you have done?
I mean, we would probably call him on the phone and take the order over the phone, or
right.
Like
you'd help them out. You want to place an order. You want to take the order, right?
Or like redirect them to our Amazon store that's selling a similar product. If I would assume Amazon has been tested for this as well. Obviously, you can't assume anything, but
take the first instance of simply why don't they just pick up the phone and try to place it on the phone, or ask you, about a particular item, what color is it, can it come in, and how much does it cost, and all that stuff, and you'd help them out, right? So I think that that approach that the courts there have in the state court have taken, that seems to make sense, and that's what we ultimately took advantage of. We filed a motion based on that precedent, and pointed out that their pleading, their complaint doesn't say what they did. It just says we tried to use your website, we had difficulty, and we sued you.
So when you did that, was there another case that used that same argument that you were able to leverage that?
Correct. We had found a prior case where that argument was accepted. And it seems like that's, at least in the state courts, that's the way to go if you do want to fight these things, is to take advantage of that set of case law.
It seems like these I'm going to call them predatory lawyers, will recognize that that's going to be the common defense, and then they'll work around it some way, or they'll transition into other areas. Are you seeing this as a cat and mouse kind of game?
A little bit. Like in your case, they tried to amend the complaint, but they didn't really address that issue that we raised. And because they did that, we pushed even harder. We said, look, now you're just really being litigious for the sake of being litigious. You're not actually trying to advance the case. And that was when they said, okay, we're done with you.
Okay. So how do you think their strategy is the back and forth is simply to drive up my costs and to get me to want to settle?
Exactly. They know that, that there's definitely some people that would rather have quick finality, that would pay some set amount and be done with it. Not everybody has, the stomach for what you did, honestly, right? Not everybody wants to go through that. Some would rather just write a check and be done with it. But for those who are willing to fight, they definitely, they will give up at some point.
As someone who, I kind of put it this way, like I do not seek out drama. I do not seek out conflict. I've never sued anybody. That's not my mentality for how I want to resolve issues. However, if someone throws a punch at me, I'm also kind of someone who's willing to fight. And one of the things that I would love as an entrepreneur is to know if there's a law firm out there that essentially only provided services to e-commerce people who wanted to fight. So it was like, oh, I'm being defended by Mark. 100% of his cases he's going to take to the end and never settle. Then I would imagine they would start to drop them super quick, right?
I would think so, but there's always going to be those who feel differently. I mean, I believe that you were recommended to me by somebody else who had a similar attitude, and we fought for until they gave up.
Yeah,
the other side gave up.
Unfortunately, he paid less than me, so I think that must have been.
I, yeah, I forget the dates, but yeah, we've done some of these cases, both state and federal court, where the other side, we've pushed them to the point where they did just walk away or just agreed that our website was, or the client's website was in compliance.
I think the other thing to remember as an e-commerce operator is that these people are not honorable people. They are not people of principle. So if you push them, they're not going to stand up and fight. Whereas us as operators who put our blood, sweat, and tears into our businesses, like we are willing to fight to the very end to defend our brand if that's something that we believe in. So if you have the stomach to kind of carry the negotiation, I want to share kind of like my strategy and my thought process. And I don't know if this is something that was common with other people you've worked with, but I basically kind of threw out a low ball offer that as starting. I think they started at like $75K, and then you may have to correct me if my information is wrong or if you can't talk about it. I started with like $3,000 or something like that, kind of low ball, and they came back at I don't know. You got the feeling it was like 10 to 20K, something like that, and that to me that was just way too far away. Like if they came in at like 7,500, I bet you we probably would have ended up settling around like $5,000. So the fact they came in super high really encouraged me to just fight to the end, like more out of principle than out of logic. And then I basically told Mark that the longer this goes on, the lower my settlement's going to be. So I kept on offering lower and lower. I don't know if they got pissed at that or like if that was effective or not, or like from your site, did you see any kind of language that indicated that was a good strategy?
I mean, they went down to a certain point. I think it was clear that they did have a floor in their heads that they didn't want to go below, as maybe as a firm or, as a matter of practice. So they sort of stopped at some point. I forget, it was somewhere in the teens, I think, that they wanted. But we let the case run for a bit, and then we, hit them with some motions, and that brought it to the end. But yeah, one of the things that you raised before, as far as being predatory, that you could do, an e-commerce seller could do what they can to try to bring the website into compliance. But there's always going to be some that you could find. There's always going to be something that's not perfect about it, right? There's a zillion of these software tools that will scan your website, and you're always going to find one tool somewhere that will show some issue. So you do the best you can. It's important to make sure your website is compliant, obviously. But if you get hit with with these lawsuits, it happens. There's only so much you can do to avoid it.
Yeah, I was going to share, like, what are some of the best practices? Obviously, having a website that is accessible. And I'll say, like, since we got Serve, like, we've made it a higher priority to continue to improve that experience for those with disabilities. So our website is, more accessible than it was in the past. But like you said, like it's been something that we've worked on in the past, but clearly, not good enough to either be viewed as like a, an easy target or whatever. Like if people just get scared and it seems overwhelming to fix their website.
Yeah. I think, right now the standard that most people want to be at is WCAG, the 2.0 that they call the intermediate level. That's sort of the target right now. And it's important, whoever does your web development, that they're familiar with these standards, that they're familiar with these lawsuits too, and that they know what tweaks to make to try to avoid them to the extent possible. Some of the things are pretty obvious, is that you want to have, for somebody that has trouble seeing, have good contrast on your text, fonts that you pick, colors, make sure that all pages have proper titles, and that way a reader can, one of these automatic readers can, provide the text audibly, to the person that's struggling to see it. But some of the stuff is just so nuanced and so, so highly technical that I doubt anybody really, is impacted by it.
What you mentioned a lot of these happen in New York. Do you know of other states that are doing a lot of ADA website, or has most of them been snuffed out?
Nearly all of it's in New York.
Okay. Because I have gotten letters in the past from people in California and Pennsylvania, but they never ended up suing me, and I just ignored them.
Yeah, I think that the actual, when it comes to actually filing the lawsuits, it seems New York, whether it's the state courts or the federal courts, that's where you see them.
What if someone is a real small operator? They don't want to mess with this at all. Could they just not sell products to New York?
You could. I mean, I think New York's a sizable market.
Yeah.
You'd want to make that choice. But in theory, yeah, I mean, the court still needs to have jurisdiction over you. It could be fairly, doesn't be anything too significant. But yeah, if you never sold anything to New York, no, you couldn't be sued here.
Yeah. I mean, they could sue you and you just shoot them a quick letter back and say, hey, we don't send to New York.
Even then, it's, these guys, again, are just a bit of predators. So it might require a motion to go through that to get you dismissed, which again might cost more than what these guys are asking.
Yeah. Now, one of the things that a lot of people have been asking is like, how do you get your lawyer fees back or paid for? Is that something that you can sue these guys, countersue them or something like that? Like, can you go on the offense at all against these people?
Not really. I mean, there's no real counterclaim you can bring against them. As far as lawyer fees, it would require you probably to go the distance to take the case all the way to the end, which it wouldn't make sense. I mean, if they've thrown up their hands and they're willing to walk away from it, that it probably makes sense at that point just to stop and take it as a win.
For those who have more fight in it than I do, what does that look like to go to the end? If you're going to,
it could take a few years and potentially several $100,000. It wouldn't make a ton of sense in the situation.
Okay, and then what would you sue them for if you were to do that?
Well, you're just basically defending, and at some point, you wouldn't be suing them.
Okay, but I mean, like
going through with the case essentially.
Yeah, I mean, like, so I guess if you're getting sued, taking it all the way, which I was prepared to do as well, but once it's done, you can't sue them back and just
no. Again, there's no guarantees that you'll get your fees back. I mean, in the United States in general, it's not. There's no guarantees that the winner gets paid.
Yeah, so it's more it's more about the principle and less about the money. So someone who's about principle and they want to stick it to them as painfully as possible and like get revenge. What's the strategy for that?
You would just keep running with the lawsuit and take it all the way through summary judgment, through trial.
So
get a judgment saying.
So when they sue me, I could just be like, no, we're not dismissing this. We're going to take it to court, basically, right?
You could. I mean, they could try to, I guess, on their own, try to ask the court to dismiss it if you refused. But yeah, you would just keep running with it.
Oh, okay. So basically, get sued and then just refuse to let them dismiss it.
Right.
Okay. So that was my mistake. I ended it and moved on with it.
No. I think it's a good outcome, and you certainly proved that you're not an easy target for these things.
Well, that's the other thing I want to talk about. So people get sued; they settled quickly. How easy is it for other lawyers to see that an e-commerce company is one that tends to settle?
It's public to an extent. I mean, somebody's going to see that you got sued, the company got sued, and there's a dismissal filed. They're going to assume that there was some sort of settlement reached, right? They may or may not know what actually happened behind the scene. In most cases, in some cases, these plaintiffs' attorneys have been able to get what are called consent judgments, where the defendant basically admits that their websites were not compliant, and that they would make them compliant in the future. So you want to try to avoid that situation, because that could certainly make you a target in the future.
Okay. Are they? Do you know how these lawyers are finding the websites? Do they have scanners? Do they have interns who are just browsing the web? Like, how do you think they're?
Yeah, I think that most of them use either, consultants, people that are a little bit more, web savvy to try to just generate links of popular websites with a lot that are doing, there are tools that'll show approximately what kind of business, certain e-commerce sites are doing. They read the news. I believe that they do follow, uh, Twitter and some of the other social media, look for people bragging about sales, which a lot of, entrepreneurs like to do. And I think that some of that stuff that you wind up putting your foot in your mouth is become a target.
Yeah, I definitely wasn't bragging about sales for the past couple of years, so I don't think they found me that way. I do wonder that because they seem to be so stubborn about that teens settlement advice. I was wondering if they thought we were much bigger than we were, because we do get a fair amount of blog traffic, which would show up in like Similar Web or Ahrefs, one of these sites, and they could see that Beardbrand gets a ton of traffic, so they must be doing way more revenue than we actually are.
Yeah, I mean, there's usually something that gives them an inkling of it, that there's some, that there's a deep pocket there. I mean, I know that you guys had lots of favorable press, and I think you were on Shark Tank at some point.
Yeah, I mean, that was 10 years ago.
But it's still something in their mind. They're like, oh, this is a company that, must be successful. So I think that's what they look for.
Yeah. Do you think do they perceive any issue in that? Like if you have a vocal person like me, I have a podcast, I'm now sharing the tips and the secrets and kind of how we went through it to fight them. It may end up biting them in the ass if we get a bunch of people who stop settling.
Right. So, I mean, I think that's good for you. I think it's good for everyone.
Yeah.
I mean, right. I mean, that's the goal, is to end these suits. I don't think that they accomplish, they're all that productive for anyone.
Yeah. They're not bringing value to the world. That's for sure. Now,
right.
I don't know. Have you run into any, I guess because you're in New York, maybe not, but there's like California privacy stuff that's going around. There's also like SMS text stuff going around in Florida. And do you have any familiarity with that? Have you seen anything like that?
Yeah, not the Florida suits. I'm not familiar with the actions that have been going on in California. We're familiar with and we've been following. There was, I don't know if this is what you're referring to. There was a slew of cases involving the chat functions on websites under the California privacy laws. They were basically, the argument that was being made was that the websites were violating the wiretapping eavesdropping laws, because some of the chat messaging was being transmitted to a third-party website without that being disclosed, or a third-party entity for processing, or maybe that data was being used without the user's consent. So there was last year in 2023, there was I believe 70 or so of these lawsuits that were filed. And initially the courts were allowing them to proceed, which was not good. But this year there's been a number of cases going the other way, where the courts have said, no, those laws were meant for traditional telephone wiretapping communications, and they don't apply to websites. So hopefully that will slowly become the end of those cases, at least.
Yeah. Are there any other lawsuit areas of concern that e-commerce people should be aware of and kind of protect against?
Sure. I mean, one of the big ones is Prop 65, also in California. They have this whole infrastructure that's intended to, warn consumers about potentially dangerous chemicals, but the laws there allow for private enforcement. So there's a number of law firms that they're just constantly looking for products, supposedly doing testing on them and filing suit. And some of those can also can get expensive.
So how do you protect yourself? Do you just have a pop-up for all California residents that say?
Yeah. So the ways you can get around it there's really two things you want to do if you're selling a product, is to test it. Number one, to make sure that it's under the minimums that California sets. California each year will issue an updated set of a list of chemicals along with the minimums. So you want to try to, have your product thoroughly tested, make sure it's under those, try to avoid an issue, and then decide whether you also want to have a warning. whether it's on the website itself, preferably is on the product too, about that the danger.
If you didn't want to go through the testing, could you just assume everything causes cancer and just put that warning up anyways? Because I think it's become one of those things where every single product you see has a warning on it.
My experience with clients is that it depends on the product. For some products, people don't care to label it. If it's a tool or something like that, where people, aren't really worried about exposure, that they're fine labeling it. But if it's a food product, if it's something, that's being, that's touted as being organic, or, especially the fitness areas and things like that, cosmetics, people don't want to label it, put this, nasty sounding warning on it. And now California changed the law recently where you can't just be a general warning anymore. It has to be a specific exposure. So, not everybody wants to put on their product, contains, will expose you to benzene or something horrible sounding.
Yeah.
So so there's that issue too.
It almost seems like it gets to a point where, I mean, again, California is a big market too, but if you're a small brand, are there any exceptions for smaller companies?
Yes, there's actually, you're not supposed to be sued if you're less than 10 employees.
In California.
If that helps. Say that again?
In California
California, under the Prop 65
okay.
statutes. But I see that in practice, a lot of companies, just a lot of these lawsuits, these plaintiffs' lawyers, they just don't care. They'll sue anyway.
Yeah. What do they consider an employee?
I believe it's supposed to be a full-time employee.
Okay. So if you have like a Filipino virtual assistant, do they consider that like an employee?
That would not be an employee.
Okay. So like American full-time employees.
A full-time employee, wherever they're happen to be located.
Okay. So that's a concern. The Prop 65. What other? It seems like there's a lot of them. What else is there?
And the ones that come to mind are the copyright troll cases. People will not always be so careful where they're grabbing photos from.
Okay.
And you accidentally grab it from one of these sort of shady photographers that are just out there to sue. So there's a lot of those, and those happen all over the country. There's a lot of them here in New York, but they're everywhere.
Those seem to be like a $500 settlement, something like that, right?
Yeah, some of the firms are more aggressive and try to seek the statutory damages and get the $25,000. It just depends. So and that's an easy thing to avoid. I mean, you can just be careful where you get your photos from. Make sure you have the rights you need.
Well, now with AI, there's no reason you just go to AI and you prompt what you want.
Well, where are they getting it? I mean, there's always some starting point, right?
I mean, I don't know. Like, that's the thing is like, how do you know where they're getting it from? I guess they got to sue. They would have to sue the AI company, right?
Well, they're going to sue you, and then it's left for you to, figure out.
But it would be a different image. Like, it's never been created before. Like the makeup would be different. There would only be maybe elements that are the same.
Possibly, but if they figure out that those elements originated with their photograph, it's for you to try to decipher.
Yeah. Yeah. Well, don't tell me I can get sued from using AI images. That's going to be another hell in the handbasket if that's the case.
Yeah, those are the main ones that come to mind: the ADA, the Prop 65, the data privacy.
So I'll expand upon like the Florida SMS thing. Apparently in Florida, they passed a law that if you send an SMS, even if they ask to be notified of messages beyond a certain period of time, it could be like 5 o'clock or 6 o'clock, something like that, then they will sue you. And it's like a per text message thing. So it's like $500 per text message. And then what they'll do is they'll notice that you went above it, and they don't sue you immediately for $500. They add all the various times that you've done it. So make sure when you're working with your SMS provider that they are diligent about the send times in Florida. I don't know if there's other states that are going to pass similar laws to that or not. California also has like the GDPR equivalent laws. Do you know what's going on with that? Are you seeing lawsuits with that?
Yeah, I think that sort of falls into the overall, data privacy and privacy policy issues. The California one's pretty strict and has some additional requirements. But in general, you're going to see over the years, I think that's one of the biggest areas where you're going to see a lot more of these lawsuits. As e-commerce providers, it's critical that you maintain your customer data securely, that if you're relying on vendors, you need to know what they're doing with it. You need to have, clear privacy policies so people can contact you and, request that their data be removed.
What, if someone's getting sued right now, what should they look for in a lawyer? Like, what makes for a good lawyer?
Well, I think somebody that's just familiar with that particular issue, whatever it may be. And, it's important to pick a lawyer that sort of understands your goals, right? That, and is within your budget, right? So everybody's in a different place. It's important for the lawyer to be clear about what the cost will be, and for the client to, be clear about what, where they want this to go, how much they want to spend on it. And that makes for a good relationship.
Yeah. What other things make for a good client relationship from your end? What should e-commerce operators be doing that help you out?
For me, obviously it's best when people are straightforward with, with what they want, with where they want to go with it. And just to, with any lawyer relationship, is to be as honest as possible about what you've done or not done, previously. So there are as a lawyer, the last thing we want is surprises. We always say, bad facts, no problem, as long as we know about them. So just to, when you're dealing with the lawyers, be as clear as you can about, all the facts and really what outcome you want.
One of the things that I appreciated about our working relationship was it felt like I kind of told you what we wanted to do, and you handled a lot of it without bringing a lot of it back to me. I felt like if you were to email me every single update or tell me everything that was going on and kind of act as a middleman, I might have gotten more stressed out. It might have been more burdened. But in working with you, I felt like I could work on the business, not be distracted by the lawsuit, and know that you had it handled.
Yeah, that's what I like too. But I do recognize that there's some clients that do want the constant updates. I felt like you gave me the direction and we can just run with it without having to bug you over little things. And that works for both of us.
Yeah.
So I'm happy about that.
Yeah, I think I would just probably email you like once a month or once every couple months, being like, any updates here. My fear, I'll tell you from my perspective, my fear was just that something didn't get filed. And because of that, like we were negligent or whatever. So that was kind of the only thing I was majorly concerned about as it went on and on and on. But lawsuits don't move quickly.
Right. There are definitely, long periods where it's just quiet. You can file a motion and it's not returnable. It's not due for several months. So in the meantime, there's not a whole lot going on.
Yeah. Where can people find you? Where can they hire you?
We're Carter, Krinsky, and Drogan. Find us on our website. You can Google me, Mark Berkowitz. We're pretty easy. Lawyers are pretty easy to find.
Just not on X, though.
No, I'm not big on LinkedIn. You could find me.
Okay, on LinkedIn. There you go.
Try to stay off the social media, but LinkedIn's a good place.
All right, guys, I hope you enjoyed it as much as I did. Thank you for your wealth of information, Mark, and thank you for helping us through this very unpleasant case. Glad to have it behind us. As always, this has been another Ecommerce Conversations. Cheers. Keep on growing.